Hello friends, my name is JJ, and today I thought I would do my best to tell you guys a bit about one of the most contentious topics in modern Canada, which is the matter of the Indigenous Canadians. When you read the Canadian newspapers these days, you will often come across stories involving the Native peoples of Canada protesting or suing the Canadian government over some big construction project like a natural gas pipeline or an oil fracking site. The idea that Canada's leaders, in response, have grown eager to accommodate an Indigenous right of veto over policies that they don't like is another thing that tends to come up a lot and is held up as either an inspiring or distressing example of a certain progressive mindset guiding the Canadian government under the rule of the Liberal Party. So what is actually going on? It is a big, complicated topic, but let me attempt to offer you a mostly objective summary. Canada, as I'm sure you know, is part of North America. And North America was once home to many civilizations of people that were then largely destroyed when the European empires arrived and built a new civilization in their place. When we look at the ethnic breakdown of modern Canada, we can see just how dramatic the consequences of this colonial project have been, with people claiming Indigenous American heritage now an extreme minority of the population. The number gets even smaller when you exclude mixed-race people. The question that Canadians are asked to confront today is what it should mean to be the inheritors of this legacy. Now, for most of Canadian history, this legacy would have been seen as a broadly good thing. In a sort of thoughtlessly chauvinistic sort of way, Canada's white majority would just say that Canadian civilization was obviously superior to the Indian civilization that had come before, so this wasn't really anything worth being too troubled by. In more recent decades, however, consensus has grown that building the nation of Canada on the land of the Native Americans was at least somewhat morally wrong, and something that we should feel at least some remorse about. Over the last decade in particular, the term reconciliation has become the preferred way for the Canadian government and many other big Canadian institutions to describe the idea of owning up to the human consequences that creating this new country has inflicted upon its original residents and attempting to undo some of that pain and damage in a meaningful way. Some of that undoing has played out in the cultural realm. Canada has seen quite a renaissance of native art and music and language and dance and ceremony and storytelling since the 1980s, which you will now see incorporated into everything from airports to football games. Aboriginal Canadian aesthetics are now often appreciated as something that offers Canada a unique character and sense of identity, particularly in the context of the age-old project of trying to make Canada seem appreciably different from the United States. I mean, there are plenty of parts of the US that are keen to embrace Native American culture as part of their sense of self as well. But while Canada and the US are both multicultural societies, Canadian officialdom has always been much more explicit about asserting a hierarchy of which cultures matter most. And in 21st century Canada, it has become common to hear Indigenous culture specifically identified as one of the three core cultures of Canada alongside the French and English. But beyond that, reconciliation also invites action in the realm of politics and law. Canada is a democracy, after all, and no one is doomed to just passively sit around if they sense that a terrible injustice has been done. Judges and lawyers and politicians and bureaucrats have the agency to attempt to impose solutions to correct for the injustices of the past. The question is, how far are they willing to go? Here in downtown Vancouver, where I live, there is a big mural painted by some Native rights activists, and it features a slogan that has become increasingly popular within this community, a slogan that offers a vision of reconciliation that is about as blunt and direct as it is possible to be: land back. So the question of what a compassionate policy for the Indians would look like is actually one with a pretty long history. The problem, though, was that in the old days, elite conceptions of what was best for racial minorities were often tied up in a lot of condescending white supremacist thinking, or at the very least, Western Christian civilizational supremacist thinking. Well into the 20th century, a lot of progressive white Canadians continued to believe that the most compassionate thing that could be done for the Indians was to educate their children in Christian boarding schools until they basically stopped being different in any obvious way and could thus seamlessly integrate into the new and better civilization that had been built on their lands. Today, this is obviously understood to have been a deeply cruel and inhumane thing to have done, even on its own terms. Independent of the disease and abuse that these schools inflicted on their students, we now understand forced assimilation of any sort to be a fundamental crime against the right of the individual to define their identity on their own terms, not the terms of the church or state. As the residential schools started to be phased out in the 1960s, Prime Minister Pierre Elliott Trudeau then suggested what he understood to be a more sensibly compassionate progressive policy. In 1969, he famously proposed phasing out the legal concept of Indian altogether, and with it, all of the elaborate colonial bureaucracies that the Canadian federal government had by that point set up to manage the lives of the isolated Indigenous minority, including Indian land reservations, Indian hospitals, and Indian welfare programs. As I discussed in a previous video, this approach was consistent with Trudeau's ideological commitment to a kind of one-size-fits-all, inclusive liberal citizenship, and his opposition to the idea of people getting special rights based on what group they belong to. Though Trudeau never personally gave up this belief, opposition among Indigenous elites to his 1969 proposal did prompt him to abandon it and change course. And what followed is usually seen as a turning point in which collective rights for Canada's First Nations became more, not less entrenched as a guiding principle of this country. In 1973, the Canadian Supreme Court made a confusing and complicated 3-3-1 ruling in response to a claim by the Nisga'a Nation of northern British Columbia that they had never surrendered control of any of their land to the British in any treaty, and thus still legally owned it. Half of the judges found this argument persuasive, half didn't, and the tie-breaking judge ruled to dismiss the case on an unrelated technicality. As you can see from this map, there are many parts of Canada where Native people were not displaced through formal treaties of surrender, but simply told or forced to relocate to Indian reservations to make way for the white man. The fact that the Supreme Court of Canada was divided on whether this was a legal means of obtaining land caused a lot of worry in the Trudeau administration, and they chose to preempt this by broadening the focus of the Canadian Department of Indian Affairs from administering the Indian bureaucracies to settling what became known as claims. This was an idea based on what had been done in the US for many years, which was to offer Indians some process through which they could file specific grievances with the government. If they had a treaty, they could demand the terms of that treaty be honored or ask for its terms to be updated. If they had no treaty, they could demand the government negotiate an agreement with them to work out a modern system of co-managing the land that would fairly compensate its historic residents. And although the exact procedures have changed a lot since 1973, this general system of the Canadian government slowly negotiating agreements with the various native nations of Canada is something that very much continues to this day. To be sure, it is a notoriously slow process. After the Nisga'a ruling, for instance, it would take nearly 27 years for the federal government to negotiate a comprehensive settlement with the nation. But when these agreements do work out, they can bring some definite closure. The Nunavut territory, for instance, which is a self-governing part of Canada with an Indigenous Inuit majority, was created in 1999 through a settlement with the native peoples of that area. In 1982, the Canadian Constitution was substantially revised, with a bunch of new clauses added that articulated for the first time the various ways in which Canadians were to be protected from discrimination. At the same time, the Constitution was also changed to grant a limited number of collective rights to some types of Canadians based on the groups that they belong to, including French Canadians, English Canadians, and yes, Indigenous Canadians. Section 35 says, the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed, with the Aboriginal peoples of Canada in turn defined to mean traditional North American Indians, the Inuit people of the far north, and the mixed-race Métis people. A year later, a constitutional amendment was passed that added, for greater certainty, treaty rights include rights that now exist by way of land claim agreements or may be so acquired. So this was important for a number of reasons. Firstly, it said that the rights that Aboriginal peoples had or would gain from treaties or modern land claims were now understood to be constitutionally protected rights. This gave treaties and settled claims an unprecedented amount of legal protection. But arguably, even more importantly, the Canadian Constitution now also recognized a rather broad and ambiguous collective right for the Native peoples of Canada, known simply as aboriginal rights. This was controversial at the time because it was seen as being a little lazy. When the language of rights were being added to the Canadian Constitution in the early 1980s, the process was quite contentious and saw a lot of different types of Canadians demanding to get their specific ideas of individual or collective rights put in. And many of the Native leaders of the time felt like they were struggling to get any recognition at all. And in that sense, getting any recognition at all, even just a single line, was seen as an important achievement in the context of a country whose political class still wasn't all that interested in Indigenous issues. But in the long term, it was precisely the vague wording of the Aboriginal Rights Clause that would proceed to have some of the most significant consequences for how Canadian law would deal with the matter of Canada's First Peoples. Now, if I may offer a hot take, it is my opinion that the Supreme Court of Canada is often not very good at its job, which is supposed to be bringing closure to thorny legal questions. In recent decades, the Canadian Supreme Court has become quite timid about issuing rulings that are too definitive in one direction or another, and instead they often try to achieve a sort of safe middle ground where dramatic declarations are avoided in favor of more moderate compromise rulings that only impose modest incremental change on Canadian law and society. Former Chief Justice Beverly McLachlin, in particular, was very fond of this idea that the authority of the Supreme Court would be undermined if the court issued too many divided rulings that pit the judges against each other and thus made the law and constitution look too ambiguous. The problem with this approach, however, is that it often results in very complicated and confusing rulings that provide far more questions than answers, which then just invites even more court cases to clarify what the Supreme Court really meant. And this has been a huge part of the modern story of Aboriginal rights in Canada. In addition to negotiating with the federal government in the pursuit of claims, Native groups now often take the government to court to make claims as well, often much broader claims about the government's obligation to obey certain procedures and protocols when doing things involving Indigenous peoples or their lands. And they justify this by pointing to the Constitution's promise to respect Aboriginal rights. And in customary fashion, time and time again, the Supreme Court of Canada has produced rulings that concede some general principle about how Aboriginal rights should be understood in Canada, but in a way that remains vague enough to just invite more lawsuits and litigation. For example, here is a book that I bought that purports to be a guide to Indigenous rights in Canada. It's not that great for a bunch of reasons, but what is most revealing about it is that it is almost entirely about Supreme Court cases, and all of these cases are quite difficult to intuitively understand the significance of. So-called landmark rulings on Native rights in Canada tend to center around very technical legal matters, like what it means to have sufficiently consulted with an Indian band, or what it means for the government to have lapsed in honoring its fiduciary duties to a treaty nation. Anyway, the point is that pursuing and even celebrating Indigenous rights in modern Canada has become something incredibly lawyerly and court-centric. The amount of money that the Canadian government spends on Indigenous affairs has really ballooned in recent years, with a lot of this money paying for both the lawyers of the various Indian bands and Indigenous governments taking the Canadian government to court, as well as the government's own legal defense. But an even bigger expense is paying off all of the enormous liabilities that the government racks up in the aftermath of these cases, which it very often loses. In this 2023 story, the CBC reported that the government's Indigenous-related liabilities over the last decade had totaled nearly $76 billion. This is actually starting to cause budgetary problems problems for the Canadian government, just because these liabilities are piling up faster than the government can anticipate. The reason for this is partially just because Native groups tend to sue the government more than they used to, but it's also a reflection of how the courts have grown more sympathetic to Native litigants in recent years, and also just the degree that the government itself is more willing to settle or just otherwise not contest cases as aggressively as it used to. But if a desire to treat Indigenous Canadians in a more conciliatory way had been slowly growing in Canada for decades, it really hit a peak when Justin Trudeau was elected Prime Minister in 2015. The younger Trudeau would often talk about how he saw the historic mistreatment of the Indigenous Canadians as the most pressing crisis facing Canada, and his government spent a lot of time outlining all sorts of new sweeping principles, clarifying what Indigenous Canadians were entitled to from the Canadian government, and the specific obligations the Canadian government would honor in order to elevate and empower the First Nations of Canada as co-equal partners in the running of this country.
It is time for a renewed nation-to-nation relationship with First Nations peoples. One that understands that the constitutionally guaranteed rights of First Nations in Canada are not an inconvenience, but a sacred obligation.
Shortly after Trudeau came to power, this seminal 6-volume report was released by a thing known as the Truth and Reconciliation Commission. The report had been originally commissioned in 2008 as part of a class action settlement between former students of the Indian residential boarding schools and the federal government. But as the project went on, its scope became increasingly grand and ambitious. No longer satisfied to merely document the history of the residential schools, the final report wound up documenting much of the entire history of the oppression of the Indigenous peoples in Canada since the arrival of the white man, with the schools held up as representing the culmination of a long process that the report famously referred to as a cultural genocide. The final book of the report, accordingly, issued 94 calls to action for how Canadian society should be restructured in order to fulfill the needs of reconciliation. And by the time Prime Minister Trudeau left office in 2025, his government claimed to have at least partially implemented 85% of these. Some of the calls to action were about symbolic things, like creating a new national holiday to honor the need for truth and reconciliation with Native peoples, or changing the oath of Canadian citizenship to include a line about honoring treaties. Others were more policy-oriented, like increasing funding for schools on Indian reserves or combating systemic anti-Indigenous racism in the Canadian justice system. The implementation of the calls to action are one of the more visible legacies of Trudeau's prime ministership, and they have made Canada a country where emphasizing the existence and distinct needs of Indigenous people has become a more omnipresent characteristic of Canadian life, and a principle almost every level of government now constantly cites as guiding almost everything they do. But it was fulfilling call to action number 43 that would prove the most dramatic. This was the one that demanded the Canadian government fully adopt and implement the United Nations Declaration on the Rights of Indigenous Peoples as the framework for reconciliation. The Declaration on the Rights of Indigenous Peoples was passed by a near unanimous UN General Assembly in 2007, with the only 4 no votes coming from the 4 Anglo-settler countries, including Canada, which at that time was run by the Conservative Party. The UNRIP, as it's known, proclaims Indigenous peoples to be a fundamentally unique class of person in the global order, existing apart from states and possessing inherent powers independent from them, which states must acknowledge and honor. This was seen as a real Pandora's box for Canada back in 2007, but in 2021, Trudeau's government passed the United Nations Declaration on the Rights of Indigenous Peoples Act, which retroactively made it part of Canadian law and stated the Government of Canada must, in consultation and cooperation with Indigenous peoples, take all measures necessary to ensure that the laws of Canada are consistent with the Declaration. By enshrining UNDRIP into Canadian law, the Canadian government was therefore explicitly recognizing dozens and dozens of very precise rights it had never previously fully conceded, including the right of full Indigenous self-government a right to an independent Indigenous legal system, and a right to withhold approval for any decision affecting the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired. UNRIP is so long and comprehensive, in fact, I would say it empowers Indigenous people to make virtually limitless claims of injustice against the Canadian state, just because it describes so many rights and defines them all in such a broad and open-ended way. Ensuring all laws of Canada are consistent with UNRIP is an incredibly ambitious goal, and it's still not entirely clear what this will mean in practice. As it stands now, it is increasingly being cited in court cases as something offering clarity and specificity to the Canadian Constitution's ambiguous promise of Aboriginal rights. Which seems like a good segue into a conversation about contemporary controversies, because all of this stuff is really starting to add up, and not everyone is thrilled with what the consequences to Canada have been. The complaint that tends to come up the most is just that Canada's increasingly ample suite of rights for Indigenous peoples is creating what we could call a regime of native NIMBYism, wherein it is getting very difficult to build any large economic infrastructure like mines or pipelines or power plants in much of Canada, just because doing something like that now requires getting approval from all of these different Aboriginal governments laying claim to so much of the country, and a lot of them are very hostile to these sorts of projects for various reasons. Sometimes there are environmental concerns, sometimes there are fears of economic exploitation, and sometimes opposition is just seen as a way of affirming a legal right of sovereignty. The idea that an Indigenous government could completely veto a major project that has been authorized by the Canadian government isn't fully established in Canadian law, but the Supreme Court does seem to be drifting more and more in that direction. In any case, Prime Minister Trudeau and now Prime Minister Carney prefer to behave as if that right exists, just because running roughshod over an Aboriginal government would seem pretty hypocritical given how much emphasis they've given to things like the 94 calls to action and UNRIP and the agenda of reconciliation in general.
I don't mind repeating myself about this because it's essential, is full First Nations partnership and participation. Referring to the MPO, the Major Projects Office, does not mean the project is approved. It means that all the efforts are being put in place from the federal government in order to create the conditions so it could move forward. But those decisions are taken by many parties, including very much First Nations.
So if the First Nations continue to oppose them, then there's a chance these projects will not go through?
Well, we'll see the decisions they're taken.
At a grander scale, there's also the unresolved matter of what happens to the parts of Canada that have never been ceded by treaties or modern land agreements. There was a big court ruling here in British Columbia last year, where a judge ruled that the Cowichan Nation should be granted full ownership of a chunk of a city near Vancouver based on their argument that they never fully surrendered it to anyone. That ruling has caused a considerable freakout just because it is not obvious what it means for a First Nation to own land in some absolute sense, as opposed to merely co-managing it in some way, which is how Indigenous sovereignty has traditionally played out. But absolute ownership of this sort is definitely something that's been sought by many Native rights activists lately. Some activists even argue that existing surrender treaties should be repealed altogether because they were signed under duress or not properly understood by the Native leaders who signed them. That's very much the argument of this book. The third controversy would be, just to state it bluntly, that a lot of people find all of this stuff just kind of woke and annoying. This is something you read endlessly about in the conservative press in Canada. That all of this focus on the plight of the Canadian Indian is basically a way of denigrating this country and its history, making Canada seem like this fundamentally wicked, racist, imperialist, genocidal place that's never done anything right. I feel like a lot of conservatives are starting to get pretty hard-hearted about the residential schools in particular. In the early 2020s, there were a lot of stories about mass graves of children's bodies being found at the sites of these former schools. And when it later came out that some of the reporting on this had been sensationalized and misleading, you started to see a lot of right-wing backlash to the idea that these schools were even bad at all, which then led to calls from progressives that denying the cruelty of the residential schools should be criminalized, sort of like what the Germans do with Holocaust denial. And then you add on to that the fact that the modern Indigenous rights movement in Canada tends to be bound up with a lot of other progressive causes like environmentalism and anti-racism and LGBT rights and even anti-capitalism. And you can see how the whole issue of Native rights starts to become just one more polarizing issue in the right versus left culture wars. When you ask conservatives what they would like to see the government do differently, however, I don't feel like you tend to get a lot of clear answers. I think a lot of people on the right in Canada tend to be pretty intimidated by the degree that so much of the status quo now seems to be entrenched by the Constitution or court rulings. So it's one of these things where a lot of people don't like the way things are going, but also don't know enough about the issue to offer clear counter-arguments. Repealing UNRIP, however, is certainly one tangible goal that seems to be gaining a lot of steam. My personal sense is that Indigenous rights will probably prove to be one of these issues where we see a bit of a pendulum swing in the coming years. I feel like it's the NIMBY angle more than anything else that is really starting to exasperate a fairly broad cross-section of politicians and business leaders in Canada these days. Just because the idea that government should be more aggressive in enabling the construction of social and economic infrastructure seems to be the consensus of Canadian elites at a time when Canada's economic growth is proving so stagnant. Indigenous leaders, for their part, will often be quick to say that they are not opposed in theory to being partners in these sorts of projects. They just want proper protocols to be followed before they award what the bureaucrats now often refer to as FPIC, or free, prior, and informed consent. But the question is whether the pursuit of FPIC is a process that actually aspires to arrive at a clear yes or no, or is just something that exists to generate more time-wasting court cases to clarify increasingly fine-grained legal questions at the expense not just of Canada's economic growth, but the lives of the Indigenous peoples themselves, who, despite it all, still remain some of the poorest and least healthy people in this country. So I would be curious to know where my Canadian viewers think things are headed. Do you think we will continue on the progressive path we have been on over the last few decades? Or do you think there is a chance there will be a dramatic conservative course correction at some point? And what would that look like? And for everyone else, I would just be curious to know what your impression of Canada's relationship with its native peoples has been like. I feel like this is a topic that is starting to make the international headlines more and more, and I'd be curious to know how it has impacted your understanding of the sort of country that Canada is. So leave your comments in the thing below. Thank you so much for watching, and I will see you next week.